participating and providing your assistance in providing proceeds to these groups. The other thing I want to mention is that we have always done these half-day programs, and some have been in the mornings. We've been trying them in the afternoon for the past year or so during the pandemic, and we found this has worked well. But we are planning for the first time a full-day program on June 24. So I'd ask you to at least save the date on June 24. We're planning 9 hours of programming with 8 separate topics, some outstanding topics, including med mal, arbitrating construction cases, trying an arbitration by Zoom and various advocacy techniques. We're having a section on class actions, and we'll have 2 one-hour programs covering ethics. One will be in the bias, diversity, and inclusion space, and then another covering lawyer wellness. So it's a great way to have 9 hours of CLE credit, including 2+ hours of ethics CLE. And again, that is June 24. I want to thank our staff at USA&M, in particular Kelly Spiller, who is the genius behind the scene making all of this happen, and we couldn't do it without her help. 2 other housekeeping items. In the materials that were provided to everyone, about 3 pages in, right behind the agenda for today's program, is an evaluation form. And this is for getting a sense of things that we can improve in doing these programs, but most importantly, giving you the opportunity to share with us areas that are of interest to you and perhaps suggested speakers in those areas, so that we can be nimble enough to respond to the needs of the folks who are out there. The other thing is on that, just behind that evaluation form is a certificate for Missouri Bar CLE. On that page, on the bottom left, it has a Missouri program number. It's the CLE number for this program. It's 668646. You'll see it on that form. And excuse me, if by chance you don't have this material, Kelly is going to send a follow-up email after the program with both the certificate for Missouri CLE as well as the eval form. Those of you seeking Illinois credit, as soon as we have the approval from the ethics part of this program from Illinois, Kelly will send a certificate for Illinois credit to you. I think that is about all of the preliminary matters. Let's get started with our outstanding program for today. The first program that is going to run until 1:55 is called The Market as Negotiation: How Negotiation Shapes Legal and Economic Outcomes and How the Law Responds. Professor Rebecca Hollander-Blumhoff from Washington University School of Law is with us and is a co-author of that article with Matt Bodie, a professor at St. Louis University Law School. All of their bios are in the back of our materials. These are folks that are absolutely the tops in their field, and let alone having law degrees, but PhDs in Rebecca's standpoint, and Matt with only an LLM from NYU. It's a very interesting topic, and those of us who negotiate for a living, and especially those who mediate, I was so intrigued with the article, and we're going to let Rebecca, are you leading off the program? Matt, you're first. We're going to have you unmute and get started. Matt, thank you so much for being with us.
All right, Rob, thank you so much. Thanks so much for that very kind introduction. It's really our pleasure to be here. Thanks so much to Kelly. As Rob mentioned, she's the genius behind the scenes, so we really appreciate her help in getting everything set up. And thanks also to Karen Tokars, who suggested us for this program. We're really happy to be here, and we're thankful that she thought of us in this context. This project is something of a odd duck, I would say, not to put you off right away, but it's something Rebecca and I were talking before our presentation. It's something that kind of falls into the cracks, I think, in the academy. I teach labor law. I come from a labor law background, and I also do corporate law. I teach contracts to first-year students every year. Rebecca, as Rob mentioned, has a PhD in social psychology. She does law and psychology classes. She's a federal courts expert, also teaches civil procedure to first-year students, and is a expert in negotiation and has long been really interested in the area, writing her a student note on negotiation in plea bargaining, which is a really article that still holds up and is cited a lot. So I'd suggest you check it out if you're interested in that. We find negotiating fascinating, I think, for different reasons, but also for some similar reasons, which is the idea of like what is happening during a negotiation is really a complicated matter. And I'm sure many of you who are mediators who experience kind of getting involved with the negotiations, or arbitrators as well, who help facilitate negotiations between the parties, can really speak to this. And we really hope that you jump in with some participation. We're going to try and save some time at the end, or plenty of time at the end, hopefully, for you all to jump in and kind of share your experiences, whether what we're saying resonates with you or not. We'd really love to hear from you. So the basic kind of premise or theme of the paper is that markets are negotiations, and that's kind of an obvious thing to think about in some ways. But our point is that we've too often treated markets as this black box. So if you have been working on a negotiated settlement and you're thinking about, well, what is the market price of something, right? Sometimes we tend to kind of treat that as if it's something that just the market spits out, right? But you, at the same time, you all know that it's not that simple, right? There may be some technological advances in figuring out what a market price for a particular house or a particular product is. It might be easier to kind of cross compare, right? We now have websites that take lots of different providers and kind of put those all together and give you comparison shopping. But at the same time, we know that there is really there's no magical formula or no scientific method, no laboratory process that will get you a market price, right? It is something that is developed through tools, but there is no real answer a lot of times. And it's often very contingent. It can change day to day, hour to hour. Those of you who've been following the GameStop share price, will know that things can really change dramatically for seemingly unknown reasons a lot of times, or reasons that one would not expect to play a role. So we both kind of brought our different areas of interest to this project and wanted to think about what it meant for markets, that negotiations are really what markets are all about. You often hear about the invisible hand, right, from Adam Smith, as the kind of guiding force behind people's decisions within markets. We think about the idea of efficiency, economic efficiency, and that markets are a way of making sure that goods and services are distributed in the most efficient manner, in arguably a just manner, right, in the fairest manner that we can come up with, right? But at the same time, we recognize that markets are often problematic and often have certain idiosyncrasies or certain ways of handling that distribution that creates a lot of unfairness as well. But people haven't really talked a lot about the negotiation process itself. The fact that we have to sit down, and again, it depends on the market, right? And I'll talk a little bit more about that later, but we have to sit down and kind of figure out what prices are. Sometimes that's one-on-one negotiating. Sometimes that's bidding against people in an auction. Sometimes that's just going to your local supermarket and pulling something off the shelf. Maybe you buy this product, maybe you buy that product, right? The price influences you, but also your sense of quality, that sort of thing. All of that, supply and demand, everything that we think about when it comes to economics, in some ways, is dependent on this idea that there is a transaction happening. And oftentimes, before that transaction is effectuated, there is some level of negotiation, right? And what does that mean, right? What effect does that have on the market? And what sort of aspects of negotiation should we think about when we're thinking about that market? So I'm going to hand it over to my co-author at this point to talk a little bit more about negotiation theory and what that theory might have to say in this context.
Okay, great. I will pick right up there. But first, I do want to say thank you so much to Rob and to Kelly and Karen for having us here. So I don't want to digress too much because I want to get right back to the topic. But thank you again for the opportunity to chat with you all about something very near and dear to both of our hearts. So as Matt kind of already indicated, right, we've got this situation where market price is really made up of aggregated individual transactions, very often. And that's just something that the market literature doesn't really focus a lot on. I look at this much more from the negotiation theory perspective, which often as well invokes the market, but invokes it in a different way, right? Saying that the market price is something that you can use as a potential benchmark, especially those of you familiar with the Getting to Yes framework. You know, how many of us have talked about objective criteria? One piece of objective criteria is often the market price. And so when you're in the middle of a negotiation, you may be referencing what a market price might be. But, you know, this sort of gets into this kind of dog chasing its own tail situation, right? Because that market price that you're referencing in your own individual negotiation is a market price that has come out of a whole series of other negotiations. You know, and just kind of put a real face on that. Probably everybody's familiar with that very happy feeling you get, say, when some new folks move into your neighborhood. Sometimes they move in from a different city and they don't know anything about the housing market here. And so they pay too much for their house. And everyone in the neighborhood says, this is great. Our market value just went up because of that. Or somebody, you know, is a poor negotiator and, you know, they pay too much. And, you know, conversely, that sort of sad feeling when somebody's a very hard bargainer and, you know, a house in your neighborhood goes for much less. So economic models really don't take this into account very often when they think about the connection between negotiation and outcomes. John Nash, a lot of you are familiar with John Nash, probably the famous mathematician from A Beautiful Mind. He famously said, we idealize the bargaining problem by assuming that the two individuals are highly rational, that each can accurately compare his desires for various things, that they are equal in bargaining skill, and that each has full knowledge of the tastes and preferences of the other. And of course, if you've ever participated in a real negotiation, you know that that is really assuming away quite a lot of the reality in play. So economists have gradually tried to increase their perceptions of other factors that might be playing a role in driving these market outcomes that are fueled by negotiation, but have really stopped with only one addition to the landscape, and that is information asymmetry. So economists often include this idea when they think about the role of bargaining, creating the market, by saying, well, we know there's information asymmetry, and that's something we have to come to grips with. But there's lots of other things that are happening beyond information asymmetry that change the course of negotiation, right? And so I do want to highlight here, and I'm going to share my screen just for a moment. I want to highlight some data that I collected years ago in pursuit of an empirical project on negotiation. Can everyone see the chart? Great. So this is over 200 pairs of law students engaged in a negotiation, and they're negotiating a dispute in the role of a lawyer for either a homeowner who contracted for some work that didn't go as planned, or a building contractor who didn't quite, finish the job. And so they're negotiating pretty much a zero-sum problem where whatever work the homeowner gets is of a certain value to the homeowner and costs the contractor a certain amount of money. And everyone has the same information right? This is not a situation where information asymmetry is driving different outcomes. This is a situation where all parties, at least everybody on side A and everyone on side B is walking in with the same shared information as everyone else on side A and everyone else on side B. And you can see quite a dramatic array of different outcomes here for the exact same problem with the exact same information. And some of you I know are engaged in teaching negotiation as well. And if you've ever had a class where you taught negotiation and gave everyone the exact same problem with the exact same information, that outcomes really vary quite dramatically. So we cannot explain this just based on information asymmetry. So I'm going to stop sharing and go back to just me and everyone else. So what do we do about that? There is another component to negotiation beyond this information asymmetry, right, that is driving differential outcomes. So in our project, we really try to identify some component parts of this negotiation effectiveness that can cause some variability in the way that outcomes are reached. So I'm going to just briefly go through what those look like, and then I'm going to pass the baton back to Matt. So the first component that we identify is strategy and tactics. And for strategy, we're talking about things like, do you take an integrative approach or a distributive approach, right? Are you looking for ways to expand the pie? Are you thinking about the negotiation as a zero sum? Also, sometimes, you can kind of think about that in the same framework as, are you cooperative negotiator or are you competitive negotiator? Are you looking to, think about expanding surplus or just claim value for yourself? Are you positional or are you principled, in kind of a classic getting to yes way? Are you interest-based, right? Are you focusing on positions? Tactics are very broad. They can include things, as varied as, are you a liar or do you tell the truth? Are you someone who uses empathies in a calculated way to, effect a better outcome? Are you good at cognitive perspective taking? That is really trying to think about what the other party is seeing as they perceive the landscape of negotiation. Are you able to use cognitive heuristics and biases? Some of the interesting literature about things like anchoring and adjustment, right? Where you throw out a number and it's very hard to move away from the gravitational pull. A variety of other psychological heuristics and biases that I don't have time to delve all the way into now, but some people are very adept at them and other people are less familiar with them or less comfortable with effectively using them in negotiation. Next thing is individual differences. So there are measurable individual differences we can look at between negotiators. This is pretty controversial. Actually, for decades in negotiation, the literature said there's nothing we can look at personality-wise that will tell us anything. There's been a resurgence of that recently, that research that has actually done some meta-analyses and suggested, no, that's actually not true. For example, the big 5 personality variables in psychology have actually all but one have been shown to relate directly to different negotiation outcomes. Another thing that I think is really fascinating is something called social value orientation. We could all take a measure right now and figure out where we were on social value orientation. That's how we're oriented towards the allocation of resources, and people are either oriented pro-socially, meaning they like to expand the pie as much as possible and then they like to divide it equally, or they're oriented in a pro-self way, which is typically broken out into either an individualist who really is only focused on their own outcome and the other party's outcome is irrelevant, or a competitor who mainly cares about maximizing the difference between what they get and what the other party gets. So that's a person who, and especially those of us in the legal field have seen this, right? A person who wants to win, right? And the winning is the absolute thing, not the amount or, the outcome itself kind of in a bubble. It's all about, whether you've done better than the other person. Other individual differences that may affect negotiation are things like people's sensitivity to fairness. There's outcome fairness, and people really differ on how sensitive they are to fairness cues about outcome. And there's procedural justice, which is one of my own areas of research. And that's about people's sensitivities to the fairness of the process by which an outcome is achieved. And there are also individual differences in people's ability to make another person feel that they've been treated in a procedurally fair way during negotiation. Just a couple other things to mention with individual differences. One, people have different mindsets. Like a choice mindset is different than a mindset with constrained variables, and that can have an effect on negotiation. And individual differences are not exactly the same as, but are related to cultural differences. Individuals who are embedded in a particular culture and then are interacting with someone in a different culture, can make a difference in negotiation as well. The next factor I want to just touch on briefly is training. Different people have different backgrounds in terms of how much they've been exposed to negotiation training and how much they've worked on the development of their skills. And that's obviously something that can change, but it is potentially a factor that can affect outcomes of negotiation, affect how effective people are. And lastly, when we talk about negotiation effectiveness, I want to mention that we did not say negotiation skill, in part because the role of this last variable I think is so important, and that is external bias, right? So sometimes people can be very skilled negotiators, but they come up against external bias, systemic bias, and that can cause people to be less effective in negotiation, even though they may have very strong negotiation skills. And so there's a lot of research that demonstrates potential differential outcome when you're dealing with issues around race and around gender. There's a very famous study by Ian Ayres done several decades ago now, where he sent people into a car dealership with the same script. So they were all supposed to be sort of the same level of negotiator. And what he found was that the first offers and the final offers made by the car dealers were dramatically different depending on the gender and race of the person who went in with the script, right? With white men getting the best offers, both initially and finally, and African-American men getting the worst, at the very bottom. And sort of down the row. So that's just what I want to say right now about some of the ways in which negotiation effectiveness can actually be broken down into some categories that we could think critically about in terms of how different factors might be affecting different negotiation outcomes. So I'll pass it back to Matt on that note.
All right, thank you. So the idea of this project is there's obviously a lot of research into negotiation, what makes one an effective negotiator, what things influence negotiation outcomes, distributive justice concerns, procedural justice concerns. What we thought was missing was kind of bringing that into areas of the law where the market plays an important role, but the absence of acknowledgement that markets are negotiations and that therefore all of these things we talk about in the context of negotiations should be kind of brought into that literature when we think about actual markets. And particularly from our perspective, being law professors, the law should take these things into account in certain circumstances when there are markets that are being regulated by law and that the law is trying to achieve a fair result, making sure that the law takes the fact that these markets are made up of negotiations into account as well. So how do we do that? First, we can create a short taxonomy of what negotiation variance would be. And so we acknowledge, right, that there are some negotiations where it doesn't really matter, or some market transactions, I should say, where it doesn't really matter about how effective of a negotiator you are, right? You might be a great negotiator, but you're probably going to say this, pay the same price for a box of cereal at Schnucks as everyone else. Maybe you can talk the cashier into a good coupon that you might not know about. One of us is better at doing that than the other of us. But there's a limited range there. Whereas if you're going to buy a house, as we've talked about, or going to buy a car, right, your ability as a negotiator might play a much more significant role. So we wanted to identify this idea that courts and arbitrators and mediators and other folks that are trying to facilitate with economic outcomes in the context of the law could take into account in determining whether negotiation effectiveness should play a role and should be taken into account. So our idea of negotiation variance is that it's made up of the characteristics of the market itself in terms of the subject of the transaction, right? So what type of market is it? What's being bought and sold? Is it a good? Is it a service, right? Obviously, a lot of variation here. We've talked about some examples, but that's one thing to take into account when we're thinking about negotiation variance by market, right? The idea is some markets have very little negotiation variance. other markets have big variance, like the slide that Rebecca put up, depending on negotiation factors. Market structure is also important. This is where there's a lot of interesting sociological research on different types of markets. So Clifford Geertz's discussion of the bazaar, the kind of traditional Moroccan or Middle Eastern bazaar, right? If you think about that sort of interaction and negotiation versus an online stock exchange, right? There are going to be different structures within different markets that create more or less ability for the parties to negotiate. Market norms and practices is our third kind of category. And the idea here is, what are the expectations of the participants in the market? Do they expect to negotiate? Do they expect to get a price, right? Is it that some people expect to get a price and other people know that there's an ability to get a different outcome if you negotiate, right? All those things should be taken into account. And I want to mention, we talk a little bit about sociologist Gretchen Herman's work on garage sales here. And my dad's mother was a real proficient negotiator at garage sales. And I think members of Rebecca's family feel the same way. So that, I think, is something that we all would recognize, right? You can go and you can buy the listed price at the garage sale and be perfectly fine. You could also go to a garage sale and wait till the end and kind of scope it out. And, you know, there are lots of different techniques that people exercise, but there are also norms, right? And sometimes, you know, if you're too hard of a negotiator or too hard of a bargainer, the seller will be like, okay, I'm just done with you. I don't want to deal with you. So, you know, it's not just a question of whether, you know, you press really hard, that can also be a deterrent, right? So the norms of that market allow for some bargaining, but not other types of bargaining, which are seen as kind of out of bounds. So really interesting, I think, to think about the role of negotiation in different markets, and depending on the type of transaction or the type of regulation you're considering, to think about what sort of role does negotiation play in this market. We think it's been underappreciated to this point. So the final part of the paper is kind of diving deeper into areas of law. And so I'm going to start us off just by talking about the common law of contract, which is something that I'm very familiar with. I have a contracts class at 2:30 today, actually, which is why I'm going to unfortunately miss the subsequent presentations, including from Ms. Barnes, who was a former student of mine back a little while ago. So I'm very, very proud of her work, and sorry that I'm going to miss her presentation. But the common law of contract doesn't do a lot with negotiation. It doesn't really take it into account. It kind of sneaks in various points. So the idea of consideration actually is this idea that you have a bargain for exchange, right? Those of you who can think back to your first year contracts class, right? We might think of consideration as, okay, each side has to give a benefit or suffer a detriment. And that's true, but the idea of a bargain or a bargain for exchange is very critical to contract law, as opposed to the idea of a gift, which is just one person kind of, giving something to someone else, kind of a unilateral action. Whereas contract is supposed to be a bilateral action, and really kind of recognizes that there is that negotiation as part of the transaction, right? It doesn't have to be an overt negotiation. And there are some cases where the courts basically say, oh, there doesn't have to be haggling before you actually have the exchange. But there's the recognition that there is a bargain at the heart of the contract. In terms of ability, we do look at folks' ability to negotiate to some extent in terms of their age, right? We say if you're under 18, that you have different responsibilities with regard to contracts. We talk about in terms of mental capacity. We also look at unconscionability. If you look at the different levels of education or other market sophistication that courts look at in some situations when we're talking about consumers, right? So some consumer contracts, particularly in the 70s and 80s, courts thought that these sophisticated companies were taking advantage of consumers who had less socioeconomic power, but they also had less socioeconomic ability to negotiate with the company and get a better outcome. But again, that not really overtly recognized there as a specific concern was negotiation. Undue influence, I think, is the area of law where you most see it, and it's kind of not very well defined, right? But undue influence is this idea that one party is in a relationship that allows it to exercise power over the other party in a way that we find distorts the bargaining between the parties and leads to outcomes that are unfair. And so that's where courts step in with undue influence. But other than that, for the most part, right, it's probably well known that, in the negotiation, the pre-contract negotiation, there's no requirement, for example, to bargain in good faith unless you've assumed that duty, for example, through labor law. The common law courts have been fairly hands-off when it comes to that pre-contract negotiation period. There are other areas of law, however, where courts have this negotiation variance to take account of. And again, to a greater or lesser extent, they've done so. So I'll hand it back to Rebecca to talk about one such area.
Okay, so I'm talking just a little bit about legal settlement, and sorry, that muted by accident. Can everyone hear me now? Probably legal settlement is an area that's near and dear to some folks here's heart. So there are a bunch of models for, why cases should or shouldn't settle. And it doesn't always kind of play out that way empirically, right? But economists have done a lot of work to try to say, well, maybe it's, when there's unclear law, or maybe it's in particular areas where there's information asymmetry. But what, again, kind of the fundamental kind of impetus for this project was thinking about, like, are there other possibilities for when cases settle and when they don't? And one possibility here is the skill and effectiveness of the negotiator. So what does that look like in this area possibly? Well, it's really hard to know. It's very complicated, right? And if you just do kind of a simple matrix of saying, like, okay, well, let's just do something really simple. Let's say, like, high effectiveness, low effectiveness lawyers in settlement. Now let's match them up. Okay, so when we have a high effectiveness lawyer, match up, is that case going to settle, or is it not going to settle? When we have really good negotiators, does it mean that they're going to find it harder to reach a good outcome because they're both going to have such high standards, or is it just going to be simpler? Two less effective negotiators match with each other. Does that mean they're sort of going to bumble their way to maybe not a great outcome, but they're going to get there? Or does it mean that they can't settle the case? What about a high effectiveness, low effectiveness matchup? How is that going to play out? Is the person who's a great negotiator just going to crush the other person and we're going to get to some kind of negotiated settlement? Or is the negotiation process going to be hampered by someone who is bumbling or ineffective? Being a bad negotiator doesn't always have to mean getting a bad outcome necessarily as well. So this is complicated. We don't have any real data on, how these kinds of matchups are going to affect whether cases will settle or not. And then there's another layer of complexity here that is sort of ignored in the literature entirely, in sort of this model for when cases will settle and when they won't, which is the role of the client, right? Because it's not just a lawyer negotiating with a lawyer. Each lawyer has their own client. Clients have different, makeups, preferences, etc. And so, that just adds kind of a whole nother layer of nuance. The dominant part of the way that the literature to date has really thought about the lawyer's role in this market for settlement is basically in the context of threats and lies, and how, lawyers can differ and how much they utilize threats and lies in negotiation, and, how that may affect their effectiveness. It's not, I think, uncoincidental that that's the main kind of legal what's the word I'm looking for? Legal check on the proceedings, right? Most settlements are largely unregulated. It's only if there's a question maybe of some kind of fraud or malpractice that the court might look a little bit deeper. So I think that this area, we're really missing so much information that would be great to have a larger sense of in order to know, in this paper, we sort of leave open what would be the role of the law in doing a greater oversight in settlement, because our contribution here is to say that this is a much more complicated area than has been given credit to date. Okay, I'm going to pass it back to Matt.
All right, I will just wrap up here with two other areas of law we talked about. One is the market for corporate control. So I had worked on a paper, and I used some of the background from that paper on the AOL Time Warner merger. And that's there's a lot of, there are 3 books, in fact, on that merger that came out around the time of the merger. And it was just such a fiasco on so many levels. But what fascinated me on some level was how that merger was negotiated, right? It was Jerry Levin of Time Warner and Steve Case of AOL basically meeting at a hotel in Manhattan, having dinner. And that, you could say there was a lot of more complex steps after that, but that was kind of really the thing. Once those 2 people decided, yes, we are going to merge, everything else kind of flowed from that. And so this is obviously something that had ramifications for, thousands of shareholders, and had really big ramifications on the market. And yet it was decided by the negotiations between 2 individuals that were largely secret. And in part, that confidentiality is important for the process, right? And it was ultimately approved by shareholders, approved by the boards, approved by the shareholders. So you could say hindsight is 2020, and we recognize it was a bad deal by Time Warner, but that's after the fact. But there is a big variation in this market for corporate control, and you do see some companies, spending much more to acquire a company than other companies. And in fact, there's some empirical literature in economics about how these deals often tend to be bad deals, particularly for the acquirer. And so we think that the idea that there's a market and we get a scientific result here depends on the ability of these people who are negotiating these deals to actually do that. And yes, there's a ton of money involved. There's a lot of expense on due diligence and the like, but there's also so much that's driven just by these 2 people in a room talking to one another and deciding on a course of action that we think we should take into account negotiation. And one way is the appraisal remedy under corporate law. Delaware law has been moving away from the appraisal remedy and has been trusting more of the market here. But we think this is an example where you might want to look into the actual negotiations that took place and think more about the role of negotiation in this particular outcome, because the appraisal remedy might make sense. It might be an important check on bad negotiations. You might just say, well, bad negotiations, that's the breaks. But again, think of the thousands of shareholders. Think of the huge ramifications of this. And again, appraisal remedy is for shareholders who are like, this is a bad deal. We don't want to participate. We want to opt out of this. We need some protection. So that's one area where we think you could think about negotiation within the law. Another area is employment. And I'll just talk very briefly about this. Obviously, this is an area where we see wide variation. There is a norm of secrecy, a norm of pay secrecy, right? The NLRA says you can talk about your pay to whoever you want and you can't be fired, but most workers keep their pay secret. Most employers want employees to keep their pay secret. And so, right, there's a lot of room for negotiation variance. Now, some of that may be based on racial discrimination, gender discrimination, disability discrimination, right? There is a lot of room for discrimination there. But as Rebecca was saying, there's a lot of complicated kind of interactions between race, sex, discrimination, and also just different negotiation styles and expectations, right? You see different, so for example, if a man walks into a room, a particular employer might say, oh, well, you have to provide for your family, so I'm going to give you a higher starting level salary, right? Whereas, their traditional gender biases would say, oh, well, I might treat a woman differently, right? Obviously, that would be blatant discrimination, but that's an area where the man obviously has a huge bargaining advantage coming in. He might be a poor negotiator and might still walk out with a bigger deal after that negotiation. So this is also an area where we think the role of negotiation variance should be taken into account. And you might say, well, that's just what they negotiated. Can we help it that person A is a better negotiator than person B? But if there are systemic biases that are influencing those negotiations, we think that should definitely be taken into consideration by courts. So, Rebecca, unless you have anything you'd like to add, I think we're going to wrap up there, and we'd love to turn to your questions.
Okay, so a couple of questions for you all, because it seems to me that when we're either negotiating or working with lawyers and clients mediating disputes, I always view it as an iceberg, and I can only see the tip above the surface. And unless they're sharing, I don't see what's below the surface. And it seems like there are so many variables. I use your example about good negotiator, bad negotiator. But what happens if you have two great negotiators, but one of them is handling a PI case and they're a corporate lawyer because it's their brother-in-law and they don't know the value of the PI case? So you have this additional variable that they don't have a good understanding on value, even though they may be two terrific lawyers and negotiators. Any thoughts, Matt or Rebecca, about when you add these additional variables to the negotiation of a lawsuit or a claim?
Yeah, so one thing I just want to say off the bat about that is I love that example because it really highlights, I think, to me, part of the problem with the economist's information asymmetry argument, right? Because you're saying this individual negotiator lacks information, but in some ways it's a question of sort of broader effectiveness. This is someone who's very effective in their field, but they don't have enough realization, whatever you might want to call it, self-awareness, to know that they need to do more research about another area, right? They say, I have, trans-substantive skills. I'm a great negotiator. I can go anywhere and negotiate anything. But in fact, in order to be really effective, they need a lot more knowledge and information in a very, field-specific way. And that's sort of like a meta level of skill to know that you need to go and get that. It's not just a question of information asymmetry, right? A really fabulous negotiator might say, I know I'm missing something. I need to bring in an associate. I need to bring in a colleague. I need to go get that information. So what I love is just how intertwined you're showing that some of these things can be, right? It's not always just lack of information. It's even a lack of an awareness of lack of information, which then in some ways goes more to a skill that can be developed, that can grow. But it's so complicated, right? I mean, and because again, then you're saying, okay, I've got a really effective negotiator. I say, well, maybe they're missing a piece of effectiveness, but they've got a bunch. Who are they negotiating against? Are they negotiating against a great negotiator, a poor negotiator? Is that other negotiator an expert in the field, but maybe a terrible negotiator, but they're going to do better because they know the landscape, or they are a great negotiator and they know the field? There's so many dimensions of this. So we don't really purport to have an answer. We're like, okay, you put all the variables in and it's going to spit out an answer for you. But I think it shows the complexity of the results, right? That no one result, can you really say like, oh, well, that just shows you what the market is, right? Because that result goes into the market calculation, just like a result that is, achieved by two people who know a lot about the field. They, once they go into the market, they don't have a special marking on them like bad data or good data, right? And then they all form part of that field. And so, that's, I think, the part that's most exciting to us about thinking about that is that, the market's not a monolith. It's just a bunch of different outcomes, and they all come from somewhere that's sort of worth tracing backwards.
The other thing that strikes me is in that situation where you have two good negotiators, one not having that experience, it's the one good negotiator, let's say it's the defense side, who knows the value of the case, but then you have this controversy in their own room of, I know the value of the case, I know what the plaintiff is demanding right now is at the very low range of value, but I want to out negotiate them, and I want to counter. And always, that I see when we're mediating these is to point out to the defense, yeah, you might get it a little cheaper, but then again, you may have the client in the other room say, you know what, I've been here long enough, I'm done. And then you have to point to the defense and say, what if the plaintiff goes to the local tavern that evening? Hey, what have you been up to, Joe? Well, I had this mediation today. And what kind of case? Car accident? Oh, I had a car accident. What'd they offer you? X. Well, that's crazy. I got 3 times X. Who's your lawyer? Well, you should call my lawyer. And all of a sudden now the value of that case to the defense just went up 2 or 3 times. So it's this kind of shifting sands environment. Another thing that you all brought up in your article, the reasons why civil cases don't settle. And I think the statistics are roughly, 2% of civil cases don't settle. And the notion that the two sides may have disagreement about precedent, where one says at a mediation, by God, I'm going to win summary judgment. The other one says, I absolutely am going to win opposing their summary judgment. And that case doesn't settle. And I'm just curious if you could expand a little bit about that negotiation when there is this feeling in both rooms that they're absolutely dead set on the state of the law and how they're going to win either on a summary judgment or at trial.
Yeah. Okay. Matt, you want me to take that one too? A little bit of negotiation. Okay. So first things first, the first part of what you just discussed is so on point, right, to what we're saying. Thinking about somebody who, here's an offer on the table and, rather than evaluating on a metric of like, that is a good outcome for me, right? That would be sort of the individualist perspective in the social value orientation landscape I just described, right? They think, no, I want to win. I want to do better, right? If that's my benchmark, I want to beat it. And that's going to make me feel that I won, right? And that is something that we don't necessarily know walking into the room. What are the social value orientations of different people that are coming to the negotiation, right? And I didn't mention, but I will now, that social value orientation also, it's not just a thing that you have, it's also a thing that can be manipulated by social cues, right? So if I somehow can kind of invoke that this is a competitive scenario, people are going to act more competitively. If I invoke that it's more of a community scenario, people are going to have more of a pro-social orientation, right? And you're adding into the scenario, the situation with the client is, totally dead on, right? Like that there's that extra layer of complexity because clients have their own whole sets of experiences and inputs that we don't necessarily know about. Okay, remind me of the second point because I had it in my head and it just went.
When there's a disagreement on the precedent.
Right. Okay, so I want to say something about that too. So that, some of the literature suggests, right, that it's in these high disagreement scenarios in the law that's when you're going to see lack of settlement. I want to just speak to it from a little bit different perspective, which is to say that in my own research on procedural justice, one hypothesis that I've had is, looking at the role of this kind of precedent in terms of objective criteria. Is that an objective criteria? Like in the same way that market price could be an objective criteria, what's going to happen in court is an objective criteria. And my own research suggests far from encouraging settlement around a legitimating benchmark, invoking precedent, invoking legal cases that you think are going to lead to your success, they actually derail the negotiation. So my research suggests like they lead to lower assessments of fairness of process and lower actual settlement, because I think it signals to the other party when you start arguing a case in a negotiation that you're not committed to the negotiation process, you're committed to that external process. So instead of being this helpful benchmarking, it's a kind of derailment process.
Interesting. Matt, any thoughts?
Well, I just wanted to build off what you were saying a little bit. I'm curious whether arbitrators and mediators think they're there, particularly during settlement negotiations. Are they there to effectuate a settlement that both parties have agreed to, or are they there to kind of help come to a fairer outcome? And so if they sense that one party is, the attorney isn't as sharp, or they don't know as much about the law, or they're not as sophisticated, or one party brings in 5 lawyers and the other party brings in 1, right? Are they there to kind of like help that negotiation achieve a fair result? Or are they like, well, I'm here to facilitate, I'm sharing information, I am helping the parties, kind of make sure they get over any kind of procedural hurdles they might face. But otherwise, if the parties agree to it, we're completely on board with the outcome. I'm curious whether like there's one or other perspective on that.
Well, one perspective is some of the things that we've taught in the mediation course back when I was teaching that at WashU, is this is about self-determination. This is, you are the neutral. It's their case. I mean, if you go to the extreme that one of the lawyers in one of the rooms is committing malpractice because they're settling $1 million case for $87,500, that's between the client perhaps and then their own lawyer. If the client signs off, and there again, we don't know what's below the surface, right? Settling at $87,500 may put, let's say, 50 grand in the pocket of that client who needs it that day to cover their kids' tuition at college, or there's a tax lien, stuff that we never know about, that will allow a party to take less than full value. Flip side, when a defendant pays more than, overpays for a case. Again, we don't always know what's below that surface. And, as mediators, you can sit and peel back the onion as much as you want, but you may never know. So it's really, in my opinion, it's about self-determination. And if they agree to it, they agree to it. And we may have some disagreements about it. It'd be wonderful to say that everyone's fair, but some cases do settle above or below what we may think is true value. Any other final comments, Matt or Rebecca?
I see we have a question, a hand up. Do we have time to take a question?
We do, and let me see if I can.
It's Jerome.
Jerry?
Yes.
Go right ahead.
The question is, has anybody done any research on the effect on markets of a neutral third party participating in the negotiation, especially where there's an impasse and the mediator offers a mediator's proposal that neither party had come close to, and the mediator throws out a number, and if both parties agree, there's a deal.
Yeah, I haven't seen any research on that. I mean, I think that it goes to, in some ways, the heart of what folks in the mediation community think is the value of mediation, right? When if you could have that, you could, sort of, as Rob was saying, the potential to put out something that a mediator thinks is in the fair ballpark and be in that zone, right? That's the ideal market that you could create. But I haven't seen any research that looks at that. Especially interesting, of course, would be what that market looks like compared to what the unmediated kind of, gladiator, dog eat dog, unmediated negotiation process looks like. It would be a really interesting research question.
Well, you look into as a mediator, I think most of us look into our crystal ball, and it's not a matter of fairness. It's a matter of, can we get the defendant to give the plaintiff X amount of money, and will there be enough wiggle room between the two parties to make a deal? So, I don't automatically make a mediator's proposal when there's an impasse, but I do ask the parties whether they would seriously consider a mediator's proposal. And if one tells me it's going to be dead on arrival, I don't do it. But there's always, I guess, the doubt in people's minds that maybe this should be settled, and as Rob pointed out, only 2% of the cases actually get to trial. And so it seems like there's always room for settlement, but.
Absolutely. And Jerry, you raised something that I'm sure is near and dear to Rebecca's heart, and that is the psychology when we make a proposal that each party knows it's not the other side's counter, it's our number, it's not their number. And when they know that, psychologically, I think it's just easier to swallow.
It does
Yeah.
away with the devaluation of something coming from the other party.
Right.
Yes, and there's a whole psychological phenomenon. It sounds like you're familiar with it, about reactive devaluation, right? Where we evaluate negatively a proposal simply because of the identity of the proposer. So absolutely dovetails perfectly with that body of research.
Super, super. Folks, great session. Jerry, thank you for that question. And Rebecca and Matt, I want to thank you and commend you on the scholarship of that article, and also suggest to all of our attendees, I mean, it's really fascinating when we look at the corporate side, the employment side, the litigation settlement side, and how this all ties together. So first of all, thank you for this, and congratulations on the article. All right.
For having us.
Our pleasure. Folks, we're going to spend just a couple of minutes, let you stretch your legs, maybe grab a cup of coffee, and we'll get started in just a couple of minutes with our next speaker.
Rob, thanks again.
Our pleasure.
I'll hang up, but hope to see you in the real world sometime soon.
And we're on time, and we'll get started. So folks, it's my pleasure to introduce our next speaker. So Rick Hunsaker is a partner at the Heil Royster firm and is the managing partner of their St. Louis office since it opened in 2018. Most importantly for us, he is a member of the mediation panel, the mediator panel here at USA&M. Healthcare litigation, COVID-19 issues. They are out there every day, and it's terrific that we have someone like Rick who can point us with some terrific research that he has in his PowerPoint that we can all refer to later, but also have us look ahead at some of the cutting issues that we may be seeing in the future relating to COVID-19. Rick, we're going to have you get started, and we'll finish at 2:50. Thanks for joining us.
Thank you, Rob. Thanks for inviting me, and thanks for all the good work you all do in the mediation and arbitration arena. While I like to mediate cases for you all, I also like to use some of your other mediators on my litigated cases. It's a great panel. I'm going to talk a little bit about the COVID-19 situation. As you all know, none of us have really lived through anything like this. And we all know that the law is sort of a mirror of our culture. And so what's happening now during the pandemic is definitely going to be reflected in other litigation as we go forward. In fact, as I speak, I know there have been a couple of cases filed in federal court in Chicago regarding the CARES Act, which I'm going to talk about in a minute. And I guess my overview statement would be, if you have a case that you're looking at filing or defending that involves a facility or a doctor's reaction to COVID-19, you're not dealing with standard medical negligence principles. You have immunities you have to look at, both federal and, in the case of Illinois, state immunities. And I'll try to work through those with you, not in a detailed fashion, but just to give you a sense of where to go and where to look should you have a case where these issues come up. Before we get there, I initially assisted a client that insures hospitals to discuss this about 4 or 5 months ago. And what's interesting is I had to update the slides to reflect the current numbers. And it's still remarkable. I mean, we're going into a new phase, which is great with the vaccines, but we're seeing some numbers rising in a number of states. So if you look at the PowerPoints on page 2, that gives you current numbers as of about 2 weeks ago, 132 million cases worldwide. That's jaw-dropping. As I said, none of us have lived through anything like that. Global deaths are over 2 million, approaching 3 million. In the United States, there have been 30.8 million cases. Numbers are still climbing, and there have been more than 500,000 deaths in the United States. One update from when I did this initial presentation is that we are now vaccinating people. And the good news is that 3 or 4 months ago, the United States was lagging behind other countries in their vaccination rates. We are now #1 internationally. And I was talking to my partner about that, and he said, what else would you expect of the United States? And yes, that's true, but there's a lot of political discussion about this, and I won't go into those issues, but some people are unwilling to take the vaccine. Some people think this is a hoax. You know, we live in crazy political times, and certainly that has bled over into this problem. So while the vaccination rates are looking good, and we can maybe see a finish line here, this continues to be a problem. We're still in the pandemic. And that'll be significant as I start talking to you about some cases that have already been filed. So if you go to slide 5, the numbers in Missouri and Illinois are also remarkable. In Missouri, there have been close to 600,000, about 589,000 cases as of a couple of weeks ago, with total deaths approaching 9,000 people. That's 9,000 citizens in the state of Missouri. And in Illinois, the numbers are a little higher because the population's a little higher, but 1.27 million cases and over 23,000 deaths. So that's sort of the backdrop. I mean, this is a significant problem, and it's a problem that's going to arrive in our offices in one form or another. For those who are practicing plaintiffs' lawyers, I expect you are going to have people that ask, you know, do I have a cause of action here for the way that this COVID situation was dealt with by a doctor, by a provider, by an institution? And certainly those of us that defend these cases, we're going to be looking at this closely, and it's all going to be very fact-based and very legal-based in assessing, do you have a case? And if you have a case, how strong is that case? So if you go to slide 6, this gives you a pretty good idea.
Rick, would you like me to share the screen where we have the slides up, or if you want to, I have you as a co-host and you can do a share screen with the slides.
I think if they've got the materials, I'll just blow through this. If I mess around with the slides, it may slow things down.
Go right ahead.
Yeah, and so in that note, I would say you have the materials, and I'll reference the page numbers here as we go along. Some of these are way too detailed to get into for 50 minutes, but there'll be things you can go back to as a resource, hopefully. So if you look at slide 6, let me just summarize that by saying, really, you're going to look at your cause of action, when the cause of action accrued. If it accrues in May of 2020, you know, you might have a different set of standards as compared to, 2 months later. So this is an evolving, constantly changing set of facts. If you go to the CDC and you look at what they were saying in March of last year, in April of last year, radically different than what we're reading today. And that's not too surprising because the medical profession gains information and changes their protocols. So that's the important point. What was a good protocol in March of 2020 is probably not a good protocol in March of 2021. So you have to figure out what the lay of the land was on the date that the cause of action accrued. And I would just say it's a constant continuum, and you just have to pay close attention to that. So let's talk about the federal immunities. There's the PrEP Act, and I'm not going to go into detail on this. It's very, very dense in certain ways, but I think I can talk to you about some current legal developments that will guide you if you have to analyze your case, whether it's from the plaintiff's perspective or the defense perspective. So at the federal level, there is some immunity. It's not absolute, but it's significant, and it may end up being so significant that it's not a case that you want to pursue on the plaintiff's side, or a case that you can win without actually having to go to trial on the defense side. So any claim under federal or state law that has a causal relationship with the administration to or use by an individual covered by a countermeasure. countermeasure is an important word, as I'm going to explain here in a moment, but that's a reaction to the COVID pandemic. You know, if a institution or a body implements a countermeasure designed to control the spread of COVID, then that's going to qualify as a potential act which is immune under the PrEP Act. And keep in mind, as I note on slide 8, that the protection is very broad and it applies, quote, without regard to the date of the occurrence, presentation, or discovery of the laws. Now, there is an exception, and this is what we're seeing in those cases that are filed. There is no immunity for willful misconduct. And that's in the cases that are being filed, that's what we're seeing, allegations of willful misconduct. So if you're a plaintiff's lawyer, you're already starting a little bit behind there because you have a higher burden of proof. But keep in mind, the immunity is not absolute. So you have to look at your case through that lens. Who are covered? Who's covered under the PrEP Act? Go to slide 9, and that talks about how that works in general. What are recommended activities is discussed on slide 10. Those are activities to prescribe, administer, deliver, distribute, and dispense the covered countermeasures following the declaration of the COVID pandemic emergency. And then there's a definition of administration. Administration is the physical provision of countermeasures for recipients or activities and decisions directly relating to public and private delivery, distribution, and dispensing of countermeasures to recipients. So what are countermeasures? I think that can include vaccines at this point. I think that could include protective devices. That could include early in the pandemic, ventilators. So there's a whole host of things that are covered by this act. And if you go to slide 11, note that there have been a number of amendments. There was an amendment on December 6th, and there have been some subsequent amendments. And I don't have the time to go through all those. I just want to warn you, like I said at the outset, this is kind of a moving target. It's an evolving process. So if you're going to bring a case or defend a case, you need to know when the case accrued, what version of the PrEP Act or the CARES Act you're dealing with. So I talked about the CARES Act. That's the next thing we cover in the slide. That's the Coronavirus Aid, Relief, and Economic Security Act. And that also includes some of the payments that have been made to people by the federal government, the relief payments. This is all part of a unified and comprehensive federal act. And the CARES Act is something you also need to look at and be familiar with when you begin to analyze a potential cause of action that you might have growing out of a response to the COVID crisis. So let's talk briefly about Illinois. I know not everybody is practicing in Illinois, but Illinois, unlike Missouri, had some executive orders, and Governor Pritzker, by executive order 2020-19, issued an immunity provision. So if you have an Illinois case, you need to be familiar with what was done at the state level and what immunities are provided. And I would also note that there were some subsequent, as we saw in the PrEP Act, amendments and changes to the immunities, to the scope and application of the immunities. So Pritzker, by Executive Order 2020-37, you can reference that on slide 16, made some changes. And then ultimately, there were some legal challenges. And at some point, the immunities that were available in Illinois came to an end. And the hospitals and doctors are saying, well, how does that make any logical sense? How is there this window in time at the beginning when the state of Illinois and the governor provided some immunities? How did those come to an end when we're still square in the middle of a pandemic? My only answer for that is Illinois politics, and that should be a sufficient explanation. So what's the legal takeaway? If you go to slide 18, Important to note that what's legally actionable after June 27th in Illinois is not necessarily legally actionable between April 1st, 2020 and June 27th, 2020. So those are the bookends, April 1st, 2020 and June 27th, 2020, in terms of the immunities that may be available to healthcare providers in the state of Illinois. I'm talking about the state of Illinois immunities, not the federal immunities. We could have a situation where the same course of conduct is subject to different legal standards. In fact, I'm confident that we will. And I would say that also, although the statutory immunity is not limited to COVID-19 patients for Illinois, there has to be a connection to the COVID-19 crisis for the immunity to be applied for the claimant who's bringing a lawsuit. Not quite sure what we're dealing with there. It's a gray area, but the standard is not that it's limited to COVID-19 patients. It may apply to family members that go into hospitals and contract COVID-19. So that's a gray area, and I don't know what the answer is going to be. That'll have to be litigated. So what do we think, looking at it from hospital defense lawyers, what do we feel are the anticipated claims that might be brought in future litigation? One would be a lack of preparedness to respond to the pandemic, a failure to diagnose COVID-19 in a patient. We've already seen cases like that. A failure or lack of adequate staffing or appropriately trained staff to respond to the problem. A delay or denial of what are called elective or non-essential procedures. I just want to talk a moment about that. This is really interesting. And if you go back about a year, we had a situation where you couldn't have elective procedures at any of the hospitals. That was completely shut down. So, people didn't stop getting sick. People were still developing cancer. People still needed, cancer screening. People still needed cancer surgeries. Those surgeries probably were not elective, but other elective procedures, maybe like a colonoscopy, were delayed. So you're going to have situations where maybe people had delayed diagnoses because hospitals took the position that, and this was all countenanced by the CDC, by the way, that we're not going to bringing people into our facilities because of the risk of COVID transmission, and we're shutting these parts of our hospital down only to focus on treating COVID. And there's a whole range of reasons for that, which include resources, applying limited and scarce resources to deal with people that were really sick, and also trying to limit the spread of the infection. So let's talk quickly about nursing home litigation. This is where we're seeing the beginning of the wave of litigation. And so remember, I talked a little bit about the PrEP Act. On March 17 of this year, not too long ago, and sorry, this isn't in my outline. I came across this after I submitted my PowerPoint, but the Health and Human Services Secretary defined administration of a covered countermeasure to mean the physical provision of the countermeasures to recipients or activities and decisions directly relating to public and private delivery, distribution, and dispensing of countermeasures to recipients, management and operation of countermeasure programs, or management and operation of locations for purpose of distributing and dispensing countermeasures. I'm not going to read that again because it's not going to be any clearer to you if I read it a second time, but it's very broad. That's the way Congress wrote it. And that's the way the HHS secretary is defining it. And so administration is really important. That's a linchpin for application of the immunity. So some of the most creative people in the world are plaintiffs' lawyers. And we know two cases in the Northern District of Illinois that have just been ruled upon, where they're trying to get around this countermeasure language as it appears in the CARES Act. And I want to reference two cases for you, Brady versus SSC Westchester Operating Company, and also Walsh versus SSC Westchester Operating Company. And these are two Northern District cases. I believe they're pending in Chicago and the Northern District of Illinois. And in those cases, the plaintiff's lawyers alleged willful and wanton negligence. So that's outside of the immunity provision, as I discussed. But also what has been come to known as a reverse PrEP Act analysis. And what that is an allegation that the facility failed to administer countermeasures. So it's an allegation of omission. In other words, you should have instituted countermeasures. And if you did, we're not going to sue you for that because you're immune for that. But if you just fail to administer countermeasures, that might be actionable. So that question has not been fully resolved. But what I can tell you is in response to a pretty comprehensive and solid and well researched motion to dismiss on those two cases brought by the defendants, the district court judges at the federal level said, you know, we don't have enough information here to say whether or not those allegations are enough to get around the PrEP Act, the immunity that's set forth in the PrEP Act. So, you know, it's early. We're still in the pandemic and we're already litigating these issues. And where we're litigating them mostly is in the nursing home arena. I'm sure there have been some cases filed against hospitals and doctors, but we know that that the initial targeting here is going to occur in the nursing home arena. And by the way, unlike Missouri, Illinois has a fee shifting statute in nursing home litigation. So that's why I think we're seeing Illinois kind of at the cutting edge of this sort of litigation. And so we're going to see a lot of judicial application of the act, definitions of when the immunities apply, when they don't apply here as we go forward. So let me go to slide 21. And keep in mind this original presentation, I've tailored it some, but this was kind of an analysis of what to expect from the perspective of medical providers. So in some ways, some of these slides are written from the perspective of healthcare providers, but I've included, you know, an analysis from both perspectives because what I'm dealing with here are you know, excellent lawyers on both sides of the fence that are trying to figure out, you know, how do I evaluate the case and what's best for my client. So let's talk first about the lawyer's playbook. As I said, the first wave of cases are directed against nursing homes. And the common theme here is that there was a failure to manage infection control. And as I'll get to in a quote from an ABA journal article here in a moment, some of these nursing homes have really bad track records on controlling infection. And make no mistake about it, it's really hard. But in nursing home environments, it's really challenging. And these institutions are on a shoestring budget. And so you're probably going to have some ample ammunition there to go back and ask in discovery, I want to know about your track record on infection control. And by the way, that type of thing is monitored by various state agencies. So you'll be able to get to that information. And if you have a case where you've got an entity or institution that is got a bad track record on infection control, we think they're going to use that as a basis to allege willful and wanton misconduct. So other things that you'll see is depending on when the cause of action accrued, you're going to have an argument that the provider should have known, should have anticipated the problem and been earlier or more reactive in the response. And you know, that's going to be a tougher argument, I think. I think it's easier to defend that from the healthcare provider standpoint. And then, you know, you remember, we haven't talked a lot about this, PPEs, personal protective devices, go back a year when it was hard to even find a face mask. Those sorts of cases are going to be out there. And the provision of PPEs or personal protective equipment, that's what the E stands for, that's going to be something that's going to be looked at closely, and I'm sure there'll be litigation there. So race quickly through the next slide, 22. What we know, and we know this not just from COVID, we know this from the real world. When you try a case, it's all about the clash of narratives, right? And what I would say here is that the only way as a plaintiff's lawyer you're going to make an effective case here, if you can get around the immunities, is if you can get a jury angry. And it's going to be tougher to do in this setting, but not impossible. So, for example, on slide 23, I quote from an ABA article from October of last year, pretty recent. This is one of these Illinois cases. I think it was filed at the state level. One of the lawyers that was interviewed for the article said, we understand the immunity barrier, but we're going to go after low-hanging fruit, which means we're going to go after the worst actors that have a poor regulatory history and no infection control procedures in place, that we're not truthful with families, and perhaps forced employees to come back to work when they were already sick with COVID. So, those are the sort of issues that you're going to have to look at closely. And if you've got a case like that, if you're a plaintiff lawyer, I think you're going to need to analyze closely what are the underlying facts. You're going to really have to look at that closely, because you're going to have to contend with the immunities, and you're going to have to decide, can I convince a jury that this is actionable? And a lot of that's going to depend on timing too. If it's early in the crisis, it's going to be harder, I think. Later in the crisis, we have more information, and if you've got a bad actor, if they're not doing what they should do, you might be able to make a more compelling case. The defense's playbook is easy to figure out. I'm just going to say healthcare heroes. How many times have you driven past a hospital and you see these signs out there saying, "Thank you to our healthcare heroes"? And this is the truth. There are a lot of healthcare providers that put their lives on the line. And there were a number of healthcare providers that got COVID and didn't survive. A number of people were, living in campers, so they didn't expose their families to COVID, so that they could go in and treat people at the early stages of the crisis. If you're a plaintiff's lawyer and you're contending with facts like that, it's going to be tough. So I would just encourage you, if you're looking at a case, try to step into the shoes of the other side and look at it objectively and say, am I going to be able to overcome some of the natural and reasonable, I would submit, positive impressions that many people in the public are going to have about healthcare heroes or the medical providers and how they dealt with this situation at their own personal risk. And it's a significant issue to look at. So just slides 25 and 26. 25 is a picture of the daughter and the mother who died in a nursing home environment up in Geneva, Illinois, after having contracted COVID, when the nursing home said, "Oh no, she didn't have COVID," and that turns out she did. And there was a lot of other concealed information. That's a plaintiff's narrative. The defense narrative is going to be our man, Dr. Fauci. And if you have your healthcare defendants portrayed as a Dr. Fauci doing the best they can in impossible situations, that's going to be a difficult narrative to overcome. So let's talk a little bit about the timeline analysis. From a defense standpoint and a plaintiff standpoint, and that's why I left these slides in here. You're going to have to look at what was happening at the time your cause of action arose. You're going to have to figure out when it occurred in the pandemic, and then you're going to have to figure out what measures, what countermeasures, if you want to quote the PrEP Act, were being taken by the facility to deal with COVID. And these slides are pretty good, and I didn't come up with them. They're things that were being populated on the internet by different insurers and different people saying, hey, this is the information that you need to be looking at if you're a healthcare provider. So if you get sued, you can go back and say, hey, this is what we were doing in March. This is what we were doing in April. This is what we're doing in May. And, it's not going to be a simple standard of care analysis. It's going to be a complicated standard of care analysis. And if you're looking at the case from either side, you're going to have to get your arms around what was the standard of care for the time that the cause of action accrued, and what was being done by the facility, what could have been done by the facility, and what sort of resources or information was available to the facility. So if you look at the slides ranging from 29 through let's see, 32, there are some places where you can look at sample checklists, and the checklists are not definitive, except they give you an idea of what you need to look at in terms of analyzing and understanding your case in a COVID context. So it's going to require a lot of work and effort on the part of the lawyer to really get enough information to then go to the next step and decide, is this case defensible? Is this a case that warrants filing a lawsuit, warrants hiring experts, warrants going to trial if we can get around the immunities? And so you have to do a lot of basic research before you start looking at those questions and answering those questions. So where can you find that information? One of the best places, and I've put the link for this in slide 33, is the CDC. And that's where the providers are looking. That's where everybody's looking to try to figure out how do you handle this. Those of us that manage law firms or have businesses that we run in the legal realm, we're looking at CDC for guidance. Do we open up our office? If we let people in, who do we let in? How many people do we let in? Do they have to wear face masks, social distancing? It gets pretty detailed, and all of us are aware of it because we're living through it. But the CDC is where you go and you get the hard data for what the requirements were in March of 2020, what the requirements were going forward up through April of 2021. And it's going to continue to change and evolve. I would tell you that for purposes of Illinois and Missouri, I didn't put the Missouri websites up there, but they're easily found. But for Illinois, you can go to the Department of Public Health. Same for Missouri. The Illinois Hospital Association has a very good website. And then this is certainly true in Illinois and also true in Missouri. Every county has a local health department, and virtually every county should have a website where they're supplying information on what the expectations are for their county, the residents in their county. So this is as much information for potential litigation that as I've ever seen. You have federal, you have state, you have local county provisions, recommendations, suggestions, requirements, and they may not even be consistent. And so that's the other thing that you need to decide. If you're bringing a case in St. Charles County, for example, you're going to want to look at what the CDC requires. You're going to want to look at the Missouri Department of Public Health and what the provisions are there. But you also need to look at what the county is saying. And I guarantee you, for sure in Missouri, but also in Illinois, there's inconsistencies between what the state's saying, what the county's saying, and then what the federal government is saying from the CDC. That's tough. How do you deal with that? Because you're going to have defenses where, well, we were trying to follow what the state was telling us to do. And then you're going to be challenged. Yeah, but the county was saying you needed to do X, Y, and Z, and you didn't do it. Well, right, but their requirements were inconsistent with what the state's saying. So, a jury's going to be scratching its head and saying, well, exactly what are you supposed to do? So I just want you to be aware that those are things you need to look at and evaluate as you're looking at potential causes of action. You run the risk of information overload. So keep that in mind. It's easy to get paralyzed by too much information. So, stay focused, understand what your case is about. If you're going to make allegations, what those allegations are, and try to stay focused. It's going to be easy to get into the weeds on this. And both plaintiffs and defense lawyers are probably going to do that as a way to defend or prosecute these claims. So you need to know what's out there and decide what you think is applicable to your case. So what information should you be looking for? Slide 35 is a good general recommendation for what you should be looking for. Go to the federal, state, and local entities that are setting forth mandated measures. And mandated measures are, this is what you expect you to do and not do. And then you should also look at recommendations that have been made for measures that are believed to reduce COVID exposure and transmission. So, that's a moving target. People are still arguing about that. But if in March of 2020, it was believed that you need to maintain, social distancing of greater than 6 feet, you needed to have personal protective equipment, and these were recommendations from various state, local, or federal entities. Then you need to look at, well, what was being done by the institution that you're claiming didn't manage the crisis appropriately, or engaged in willful and wanton conduct. Again, requirements for PPEs. Also, another issue, and I sort of touched on this, what about access to your facility? We know that there are going to be cases where people may be able to trace where they got the COVID exposure. And if it's from a healthcare facility or nursing home facility, there may be an allegation that there should have been restricted entry. And I know because my daughter is a college student and she was a volunteer at a hospital up in Champaign, Illinois. We could not get in to see patients if we wanted to, family members. And the only time at certain points during the crisis that you could do that was if the care providers believed that the patient was on death's doorstep and you were saying your final goodbyes. Not all hospitals implemented those sorts of strict regulations. So again, you need to look closely at that. And then the other issue, and where you're going to need to consider potential sources of information, is on how quarantine requirements were implemented. And this applies not only to patients in the facility, but also to employees. And in one of the early slides, I think I made a reference to information I got from the CDC on the number of employees in nursing home settings that actually got COVID. And a number of those people died. But then the other issue there, not surprisingly, is if you have somebody in who has COVID and you don't have effective quarantine measures in place, now you're exposing elderly people that are at risk to COVID. So that's another theory of liability that we're going to see play out, is how was this transmitted? Did you as a facility engage in appropriate quarantining measures? Who are you letting into your facility? Did you have screening? We all know about screening. You're tested to see if you've got fever. You got to answer a bunch of questions. These typically are CDC questions. So you should be looking at that if you have one of these cases. And if the facility was doing all of that, it's just going to make it that much harder to win a case where you've got a family member who's bringing an action that they've lost a loved one, or maybe a patient, who had a catastrophic or profound COVID infection, that has left them with a disability. And there are a bunch of those patients out there as well. So one thing that you should be looking at, and everybody should be thinking about, including defense lawyers and healthcare providers, what are you doing with this information that you're collecting from these various sources that I just talked about? And it's reasonable to expect that a hospital or a nursing home would keep a record of what they were doing at any given point in the pandemic. So you should ask for that information. And if you're representing a healthcare provider, you need to make sure that that information is saved and not lost. So at the particular time that the cause of action accrued, again, that's critical on a lot of levels, immunity and what the standard of care might be, and whether or not you've got a basis to actually carve out a willful and wanton claim, or purposeful willful misconduct claim. You need to be knowing what was in place for that sort of thing. You need to, the healthcare facilities need to document their efforts early on to obtain PPE devices, ventilators, protective clothing for the doctors and healthcare providers. And all of that stuff should be documented, because you're likely to get a defense that, yeah, we knew we needed more personal protective equipment. We knew we needed more ventilators. We knew we needed to bump up our staffing. We just couldn't do it. There weren't people available to do it. The equipment wasn't available. And that's going to be a defense in these cases that you have to evaluate. But, if that defense is raised from the other side of it, you're going to need to say, okay, show me what your efforts were to get this material, this protective material, this material designed to deal with the spread of COVID. Also, keep in mind that, there's signs, and we see them everywhere now. You can't enter unless you're wearing a face mask. Hospitals had all sorts of warning signs and things like that. Asked to see what was posted. That information should be saved. So if you've got an inappropriate access to a facility where somebody came in and gave a patient or a healthcare provider COVID because they didn't have strict enough quarantining policies in place, then you want to know what the hospital was doing and what message was being sent to the public. Websites for hospitals are also good. So you might want to ask, what was being displayed on a hospital's website at a particular point in time. I think there's no case law on this, but if you go to slide 37, spoliation of evidence, I think could become a potential issue in these cases. So if you can survive the immunity and you're a healthcare provider and you're raising one of these defenses, we did everything we could. This is what our policy was. But there isn't sufficient evidence to support the claim that they did everything they could, or that their quarantining protocols were appropriate, so they can show pictures of what was displayed on the doors or the access points to their facility. Spoliation may become an issue. So that's something to keep in mind. And that cuts both ways. The healthcare providers are being told, save everything, so that you can prove up your defenses, because this is going to be a moving target. What's actionable in May of 2020 is not actionable in September of 2020. So it goes. And so there on slide 38, I talk about websites and public proclamations that are being made. Again, I know the risk of information overload is omnipresent here, but there are all sorts of pieces of information that were circulated by hospitals, by health departments, by nursing homes, by physicians' offices. I mean, let's say you needed to get in to see your physician in a private office. Same deal. So look at community resource links, YouTube. There might be video updates for particular hospitals. You want to look at that and save that. Symptom trackers. Those are things that hospitals were employing and using, software platforms. So you might want to look at that. What visitor restrictions were in place? There were COVID communication hotlines figure out what information was being communicated on those hotlines. And then a lot of the websites have a section about frequently asked questions, and those can be very useful. So let's talk a little bit about standard of care. Every case involving medical care, as we know, is going to hinge on a standard of care analysis and whether it was met in any given case. So as I said at the outset, the standard of care is a moving and evolving target. Now, that's not foreign to us. I mean, we know that standards of care change in medicine, but I don't think we've ever seen anything where the standard of care evolved and changed as rapidly as we've seen over the last year. As I noted, every month is different. And I know I've said that a number of times, but it's critically important in your analysis of this type of case to know what the standard of care, what the recommended standard of care was for any given point in time during the crisis. The other point is, in many medical cases, you can get the experts to agree on certain propositions of what the standard of care requires. There's usually a difference of opinion, but you're able to agree on some basic precepts. You know, nobody's going to disagree in a colon cancer case. If you have rectal bleeding, you need to recommend that the patient have a colonoscopy. Every expert's going to agree on that. And what I'm here to tell you is you're not going to have agreement among the experts in these cases. And that's something else to consider when you're evaluating, is this a case I really want to file? Or how strongly do I feel about taking this case to trial in front of the jury? Standard of care is a moving target and everybody's going to disagree. And that we know why. It's because this came out of the blue. We didn't know a lot at the beginning. We're gaining information. Things are changing. We're getting a little better, but we're still seeing infections. We're still seeing variations of the virus. We're still questioning, are these vaccines effective? I mean, we're going to see probably some litigation with Johnson & Johnson. Just 2 days ago, there was all sorts of information in the news about some patients that are developing blood clots. So, I mean, this crisis reaches everywhere, and it's going to touch everything, every aspect of how the medical profession has responded to the pandemic. So, how to fight and win COVID claims. This is slide 40, and I could say this about any type of medical case, but the issues here are just a little bit more nuanced because of the way things have changed and are moving and evolving. But first of all, narrative presentations are always going to be the way to go in a case like this. And if you look at that article in the ABA Journal from October about the nursing home case that was filed, and their ABA's initial analysis of COVID litigation, the plaintiff's lawyers talk about how they're going to develop their narrative. And it's a lot of what I talked about earlier. They're going to try to establish that the institution didn't care about infection protocol, infection control, and they're going to say this was a recipe for disaster 5 years ago, and that's why we had an outbreak here, and they're going to try to get around the PREP Act and some of the state immunities if it's an Illinois case. So the other thing is that you need to expect that there will be detailed factual narratives on how COVID impacted healthcare providers in their efforts to protect and treat patients. That's really important. You're going to see, and this is a soft underbelly if you're bringing a plaintiff's case, these healthcare providers, unlike lawyers, they're on the front line risking contracting COVID. And that's going to be a narrative that's going to be hard to overcome if you're a plaintiff's lawyer. And, I just would say it's like healthcare heroes, and you see those billboards and signs everywhere, particularly when you pass a hospital. That's going to resonate with some jurors. Maybe not all, but definitely some. And then, again, I would say if I were looking at a case to take or not take, I would say if I'm a plaintiff's lawyer, I would want a case where there's clear evidence of conscious indifference or willful conduct on the part of the healthcare provider. Otherwise, you may be rolling the dice. But if you got a case like that, I think that's one to pursue. So that basically is, view from 1,000 feet up. Hopefully this PowerPoint will guide you if you're looking at these cases. And I just want to close by saying thank you very much for the opportunity to speak with you all. I raced through the names here, and I know I'm speaking to a very august body of lawyers and mediators. So thank you for that opportunity.
Rick, thank you. Outstanding talk, and I commend all of you to take a look at Rick's material. It's 40 plus slides that has a lot of the richness of what was presented and the research that was there. And Rick, thank you. Terrific job.
Thank you, Rob.
Very good. Folks, it's 10 till 3. We are actually right on time. Let's take a 10-minute break and we'll get started again at 3 o'clock. Okay. Why don't we get started? So after this break, we're in the home stretch. Our last program is Who's Bias? Not Me. Latasha Barnes is an attorney with the Neighborhood Vacancy Initiative at Legal Services of Eastern Missouri. And we first met Latasha when she was with Land of Lincoln Legal Aid, East St. Louis, if I'm not mistaken. And we were thrilled that 2 years ago, she presented a similar program at our Illinois best practice seminar that was done in Collinsville. So Latasha works with individuals and organizations around the bi-state dealing with race equity as a trainer to strengthen and elevate their mission using an equity lens. As Professor Matt Bodie shared earlier before you came on with us, Latasha, he mentioned, oh, Latasha was a student of mine. I think he referred to you as Ms. Barnes. Having graduated from St. Louis U Law School, bachelor's from University of Georgia. It's really our pleasure to have you share this very important topic for all of us, and look forward to having this finish up at 4 o'clock. The Zoom is yours. Thank you so much, Latasha.
Thank you, Rob, and to our hosts for having me. I am sharing my screen. Just want to make sure everyone can see that clearly. Thumbs up if we're okay.
Very good.
Perfect. Thank you so much. Good afternoon. And again, my name is Latasha Barnes, and my pronouns are she and her. I am an attorney with the Legal Services of Eastern Missouri. We provide free legal aid services to Missouri residents across 21 counties, and we are dedicated to improving lives, promoting fairness, and creating opportunities. I am also a member of the Shriver Center's Racial Justice Institute, a national leadership network of advocates advancing race equity across the country. I am very grateful to be with each of you today. Now, for those in the legal profession in any capacity, whether as a volunteer, a practitioner, a mediator, an arbitrator, or a judge, recognizing the ways implicit bias influences our choices and our approach towards legal issues can have a significant impact on the way we structure our practice and build a legal system that really cultivates competency and ensures justice for all. The goals of today's discussion are to foster a commitment to the elimination of bias and divisiveness in our legal system, to ensure our legal system provides equitable, efficient, and effective service to all clients, and to promote greater integrity and civility within our profession. Together, we're going to view just a few techniques, and I want to reiterate, it's just a few techniques and tips that we can use to interrupt bias and promote greater inclusion. But before we start, I'd like to address the elephant in our virtual room. I've been doing this for a couple of years, and I will say talking about bias or diversity or inclusion can be very challenging for a lot of people. These subjects often provoke strong feelings of anxiety, defensiveness, anger, resentment, shame, and guilt. And that's just to name a few. And for those who have been personally impacted, it can trigger past feelings of hurt and hopelessness. As a disclaimer, there may be images in this presentation that are triggering at times, but I'm hopeful that we can continue to engage in this conversation in a manner that is respectful and considerate of varying viewpoints. Some things have to be seen and some things have to be heard in order for us to grow together. So let's jump right in. We're going to take a moment, and I am going to ask you to really reflect on your core values. What do you value as a practitioner, and what do we as a collective value in our legal profession? And if you would, in the chat box, include one or two or however many values you think in response to these questions. What do you value in your legal practice, and what do we as a profession value together? I'm seeing some good suggestions come in. I always say fairness, that's always at the top of my list. I also see professionalism and civility, honesty, trust, justice, and fairness again, kindness, ethics, advocacy, zealousness, impartiality, right? Experience, competence, diligence. These are all words that come to mind when I am thinking about the profession of law. I see trustworthiness, adherence to professional ethics and civility. All of these things are tenets and values that guide our work, and they reflect who we are as a profession. These values also impact how justice is administered, and more importantly, how our system, our legal system, is perceived by those who access it. And these same values are reflected and memorialized in our professional rules of conduct. So looking at Illinois Rule 8.4 on misconduct, it lists various activities that constitute misconduct within our profession. And I'm going to draw your attention to subsection D, which highlights that it is misconduct to engage in conduct that is prejudicial to the administration of justice. And if we move forward to subsection J, where it identifies that discrimination based on race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status is also a form of professional misconduct. And if we look a little further at comment 3, we would see a further explanation, right, of these words. And it really highlights that any lawyer who knowingly manifests words or conduct that that demonstrate bias or prejudice against someone based on a protected class, or when their actions are prejudicial to the administration of justice, these are things that really impact our ability to operate at the highest tenets of our faith. Our professionalism. And when we take all of these things together, Rule 8.4, subsection D, J, and comment 3, it really highlights the role that bias can play in our ability to maintain and uphold these values that we ascribe to. Particularly, it is important in how we are able to really promote a strong and trustworthy legal system. So this is why we talk about bias, right? This is why we have these conversations, even though sometimes they become a little uncomfortable. Sometimes they're difficult for us to sit through and have to repeatedly listen to. But it's important for inclusion and cultural competence, and to ensure that we are at all times upholding those values that we ascribe to. Bias, disrespect, harassment, or discourtesy by any legal professional erodes public trust and confidence in the ability of our legal system to fairly and impartially administer justice. But cultural competence allows us to use our awareness and understanding of our differences to really preserve the honor and dignity of legal practice. And in a firm or an organizational setting, this can really be seen as using our differences to maximize our group performance, to better serve our clients, to better achieve our client outcomes, and to minimize the potentials for barriers and conflict across the differences. So let's talk about bias. What is it when I say bias? What am I referring to, and how does implicit bias more specifically manifest in our work? Bias is a human trait that results from our tendency and need to really classify things around us. That's a natural need that we have. It allows us to process information quickly, right? And so any and all characteristic can, in our mind, create an image of that entire person or that place or that thing and group them into categories with similar things, right? So one thing I always tell people, when I first moved to St. Louis, it was really strange to me that people would ask me what high school I went to. I did not understand that at all. That was not what we did in Atlanta. And it was always, I was very curious about it. And I would always ask, why is that important? I don't understand. Like, well, I went to Lassiter. Unless you were in the band or played an instrument or did color guard, you probably don't know who you are or know anything about our school. But then I quickly learned that high school identification became a very easy way for people to identify potentially what your socioeconomic status was, what your upbringing may have been like, and, you know, who you may or may not be as a person, what you may believe, what you may like. And really at the end of the day, whether you were worth having the remainder of that conversation. I hate to say that, but that's kind of a St. Louis thing, right? That's what they want to know, and for a lot of reasons. And so whether it's political party, whether it's neighborhood or state of origin, or even within our state, city of origin, right? When I practiced in Southern Illinois, I had a very specific idea of what it meant to be a Chicago-based attorney, right? And when I met attorneys from Chicago, they had a very specific idea of what it meant for me to practice in Madison County, right? And sometimes our assumptions of one another were not in alignment with the people that we were meeting in those circumstances. But that's how bias works, right? We're trying to find ways to process the world around us. We're grouping things. And sometimes those groups that we place people, places, and things into, the categories assigned to those, don't always line up with the experiences that we have with other individuals. So explicit bias, and we're not going to talk a whole lot about explicit bias today, but it's the most commonly recognized form of bias. With explicit bias, individuals are aware of their prejudices and their attitudes towards certain groups, whether they are positive or negative. These preferences for particular groups are conscious decisions. These are decisions that people make, right? So we're talking about overt sexism, overt racism, overt homophobia, right? And comments along those lines are example of explicit biases. So whether that's a stereotype, a prejudice, or discrimination, all tend to be very explicit in nature. Today, we're going to spend a lot of time talking about implicit bias, or those unknown, those subconscious or unspoken preferences that all of us hold, including myself, right? None of us are exempt for those. And what's important to know is that implicit biases are automatic, they are often involuntary, they are pervasive, and they can be both good and bad. So I can have a positive association, right, between two concepts, or I can have a negative or an unfavorable association between two concepts. We're going to talk a little bit more about how this works on the next slide.
Are you seriously considering homosexuality?
Tasha, we're not hearing the volume.
Let's try. Let's try this.
Are you seriously considering her as a candidate?
Just don't trust
She's a
her.
woman.
She's a
This is a
woman.
man's
She's
job.
clearly not
Really
educated.
not. Does she even speak English?
That's not me. I'm not like that. You call it an honest mistake. Science calls it a blind spot. Our unconscious mind is a mysterious and powerful thing. It makes 90% of our decisions without us even knowing it. Our brains are overloaded with 11 million pieces of information every second. Yet we can only process about 40 of them. So we're wired to make cognitive shortcuts, using past experiences to make assumptions. And you know what happens when we assume? Our unconscious mind can put us on autopilot, determining where we sit, who we eat lunch with, who we turn to for advice, and who we choose to offer a helping hand. Living our lives with blind spots can put us in a tunnel. Same point of view, same decisions, same outcomes. We can find ourselves trapped in the land of snap judgments and misconceptions. We've all been on both the giving and receiving end of blind spots. Think about it. Who's talented? Who's able? Who can I trust? Who belongs? We've all been there. Blind spots are part of the human condition. Our choices have consequences for us and the people we interact with. By accepting that blind spots exist, we can stop. Imagine what possibilities exist if we could do it all over again. Different perspectives, inclusive relationships, diverse networks, better outcomes, seeing people for who they really are. People like you, with unlimited potential. We all have blind spots. Once you accept that you have them, you can choose to do something about it. It's time to check your blind spots and focus on what's possible.
So we are living in a time when great efforts have been made to remove overt symbols of hate and inequity. But whether people are aware or unaware of implicit biases, these blind spots are often revealed through our tendency to act or respond in ways that really communicate to other people beliefs and assumptions that we hold subconsciously, whether they are at odds with our conscious values or not. So on the slide before you, I listed examples of things that I've heard in my professional legal career as a young woman, things that other people have said to me or about others in front of me. And the way this might play out is we as individuals, right, we talked about our values earlier, and we identified what those were. Sometimes we say, okay, you know, I really believe in equality. And for me, I believe in equality of the sexes. But maybe I automatically use male pronouns when I refer to a judge that I have not met or that I don't know. Or for example, I believe in equal opportunity, but I subconsciously assume that when people talk about diversity in hiring, that actually means they're going to hire a less qualified candidate. Or for example, maybe I believe it's important. I consciously and intentionally believe that it's important to treat all people with dignity and respect. But I frequently misgender trans clients by repeatedly using the wrong pronouns, or I intentionally misgender trans clients by using the wrong pronoun during cross-examination because that's a tactic that'll help me get what I want. At the end of the day, these things all communicate biases that we hold, whether implicit or explicit, but more importantly, our subconscious beliefs are revealed through our microaggressions, right? Whether they're micro assaults, micro insults, or micro invalidations, these everyday slights, put downs, and insults from often, at times, well-meaning people who may actually be unaware that they've said or done something offensive can erode our professionalism and really impact our abilities to effectively serve our clients and to demonstrate that our legal system is promoting justice for all. Microaggressions are more than just insults. We're talking more than just insensitive comments or these generalized rude behaviors. These are the types of remarks and questions or actions that are particularly problematic because they pertain to a person's membership in a group that is often marginalized or the subject of negative stereotypes. It usually relates to a person's race or their gender, their sexuality, their ability, right, their disability status. And whether these incidents are subtle, whether they're intentional or not, their impact can and often destroys our culture of inclusivity. So for example, telling someone of a different ethnicity that he or she speaks excellent English, right, communicates a culture of that is lacking inclusivity, a culture that is not as welcoming as we would like to have. Another example might be touching a Black person's hair or inquiring if it's real, or asking your LGBTQ colleague about their sexual preferences, their body parts, or their sex assigned at birth when there's no relevance to that topic. Or otherwise stereotyping someone's cultural interests, right? Assuming your Indian client likes Bollywood, or repeatedly interrupting someone from a marginalized group to clarify what they're trying to say, or to tell them how they should feel about a perceived bias, or to correct them when they articulate discomfort with something that they've experienced that they feel was prejudicial or racist or sexist in nature. These are all microaggressions and micro invalidations that really erode our ability to work well together, to be civil with one another, and to effectively serve our clients. Many people work hard. I truly believe that many of us work hard to eliminate bias in our own decision-making, right? And we work hard to eliminate bias in our behaviors. And we often assume that we do not allow these things to prejudice our judgments or to influence our decisions. But because these blind spots exist in our lives, we often believe that we are better at understanding and controlling these things than we really are. And when we think we are good at controlling for something, we often become pretty lax in our ability to respond when those things arise, right? Or we justify those things. So for example, there's this concept called confirmation bias. And confirmation bias is the tendency to search for, interpret, favor, and remember information in a way that confirms your own biases while giving less thought and consideration to alternative possibilities. So I'm going to give you an example of this. One I like to use a lot, because I have a very amazing 16-year-old, and he's wonderful and amazing. He's an honor roll student. He's the brightest kid. All of his teachers love him. So if my son comes to school and a teacher knows and they like him, and let's say he forgets his homework, or he brings that teacher a gift, that teacher is going to assume the best of my son, right? They're going to assume the best intentions. Even though he forgot his homework, they're going to assume that he did it because they know and they like him, right? Or if he brings them a gift, they're going to assume that he's doing that because he's such a sweet child, he's so caring and loving, and he is, but that they're going to place that intentionality behind that gift, right? But if my son was like I was at his age, a little rude, a little mouthy, a little aggressive, like to fight, and I forget my homework at home, or I bring a gift to my teacher might assume, right, that I'm not telling the truth. My teacher might assume I'm trying to be manipulative by giving her a gift or giving him a gift. And that's how it works, right? When you like someone, whether you understand why you like them or not. Sometimes you meet people and you're like, I'm really taken with this person. For some reason, I like them. You know, they remind me a lot of myself. And when you like yourself and people remind you of you, you see the good in everything that they do. So you can justify, oh, they were late filing that pleading. Oh, they're a really good person. They're a really hard worker, really smart. Let's excuse that. That's fine. But maybe they remind you of someone you don't like. And you may not even realize that you just have this really bad feeling about this other attorney. And they were a day late filing a pleading. Oh no, they're lazy, right? They're incompetent. They're not diligent. I can't believe their client hired them. They should fire them. And these things are true. This is how we ascribe, right, credibility to individuals we don't know. We're trying to judge their character in situations, whether it's per people, places, or things, right? If our subconscious experiences with things really influence how we perceive people and how we perceive places and how we understand and how we justify or not justify events that happen. And these are all motivated oftentimes by our subconscious beliefs. And they're manifesting in so many ways in our society. Whether while our conscious bias and preferential treatment is mostly forbidden by law and culture, there are unconscious mechanisms that are deeply embedded, right, in various aspects of our societies. And there's biases that persist and they unconsciously shape the way we view things, the way we live, where we work, how we socialize, who we ask for help, who we offer mentoring and opportunities to, how our law firms are set up, how we practice, right? Which bar associations we engage with, how we participate in certain bar associations. These biases really create outcomes that reinforce stereotypes and that fuel continued prejudices. And they're often reflected in our institutional policies and arrangements. They're often reflected in our professional decision-making, right? And they compromise institutions where equity and fairness are critical. So for example, we think about the healthcare system or we think about the education system. These are systems where equity and fairness is critical. Everyone deserves quality healthcare access. Everyone deserves quality education. And for individuals working in those professions, they often have very noble desires, right? We want to help people. We want to heal people. We want to be there to serve people. But studies have shown that implicit biases have led to so many disparate outcomes in these institutions where fair and equity are essential, right? And I could go through study after study that talks about how LGBTQIA, that community receives different health outcomes as a result of bias. I could talk about how children of color are less likely to get the needed medical tests or medicines that they need compared to other kids within our healthcare system. I can talk about what happens in the education setting, right? Across lines of differences. And a lot of times these decisions are being fueled and they're really being perpetuated by these implicit biases. And our system is no different, right? And so we think about implicit bias in our legal profession. And so I am going to ask you guys now and really just to give you an opportunity to share, has there been an instance in your practice where you have witnessed or whether in your interaction with colleagues or your representation of clients, where you've really witnessed someone acting on a bias? And you are, I'm encourage you to think of something that may have occurred in a professional setting, but if you have a personal example that you wish to share, please do feel free to do so. And you can do that now in the chat box. So while you guys are gathering your thoughts and adding your examples, I will share an experience that I witnessed in the courtroom once. I was with a colleague who is transgender, and the colleague's name assigned at birth was not consistent with their appearance. And so when this individual met the judge and told the judge what their name was, the judge very loudly and somewhat embarrassingly was like, "What?" And so this individual whispered again, to the judge what their name was. Was a very masculine name. And it was not consistent with their appearance. And so in that particular occasion, they were wearing a dress to court. And the judge was like, "Did you really say that your name was X?" And it became a very embarrassing exchange for my colleague in the courtroom in front of plaintiffs and defendants and clients who were there and other attorneys. And at the time, I don't believe the judge really recognized, the impact of what they were doing. And we did have a conversation. We approached the bench and spoke to the judge very privately. But that type of interaction, and while that judge, very kind person, really was responding in a way that communicated hostility to that attorney, made that attorney very uncomfortable to practice in that courtroom or to take really any cases in that courtroom moving forward. So I see a comment from Lee Patton regarding an example of implicit bias in our legal practice. Lee, would you like to unmute and share a little more detail regarding juror bias? I don't know, maybe we're not able to unmute you. But Lee says in the comments, juror bias against, are you unmuted now?
It looks like he's unmuted, but we can't hear him. It's juror bias against overweight folks.
Oh, okay, juror bias against overweight folks. That's a great example. That is, oh, thank you for that comment, Lee. That is a great example. I would say that is something that happens often. How do we perceive, what are our thoughts of people based on their weights, right? What characteristics do we automatically assign to individuals based on their appearance? And that is a very important example. I will say also individuals who are lower income, right? So if you come to court and you're wearing your best, but maybe it's not as nice as everyone else's best, what that may mean, what that may mean for how individuals interpret your credibility. I'll say my first time appearing in a courtroom as a young woman, my opposing counsel refused to believe that I was an attorney and proceeded for about, I would say 15 to 20 minutes to talk to me as though I was my client and even asked me to show my bar card to prove to him that I was an attorney. So these are things that are really playing out, and I'm sure you all have many more examples. And we'll just kind of move forward. There have been so many studies that examine how bias manifests through our court systems, right? Whether in the criminal justice systems, when we're looking at how people are charged, what plea bargaining arrangements are made, how facts are determined, the credibility of our witnesses, what dispositions and sentencing outcomes there may be. There have also been a number of cases that look at how it impacts civil courts, so how it impacts their jury awards, judicial decisions, again, credibility determinations. How do we, who do we feel are more credible than other individuals? How do we compare experts, right? And some of those things play out in how we measure the credibility of our experts and choose which experts we find more credible than not. More importantly, it impacts how we interact with our clients, which individuals we decide to bring on as clients, how we make our merit determinations. Is this a good case or not? Is this case worthy of my time or not? What case strategies we may pursue, and really how we decide to kind of frame our legal practice. Which clients are we really looking to serve? Who are our ideal plaintiffs? Who is my ideal witness for this case? What does this individual look like? And what does that convey to a jury? What will that convey to a judge? There are so many ways that bias is really kind of influencing every aspect of our judicial system and our professional practice. I would be remiss if I did not take some time to really talk through how we can address that. The good news is that biases are malleable. Our brains are incredibly complex, and the implicit associations that we form throughout the years can be addressed through a number of techniques. So first, identification, understanding the bias through testing and really raising awareness of what bias is, how it manifests, and what we can do to address it. And then mitigating it, both in our personal lives and in our professional decision-making and in our professional circles. And then lastly, interrupting. So the first step is really to identify our implicit biases. And we can do that by taking an implicit association test. The implicit association test measures our association between different concepts. But we are faster at grouping concepts that are closely associated in our mind. A common association might be milk and cookies. Cookies are often strongly associated with milk, right? You see it in media, you see it in ads, you see it everywhere. You think of cookies and milk for Santa, you think of cookies and milk before bedtime, and this connection automatically comes to mind for a lot of us. Now, if I were to ask you to make an uncommon association like cookies and mustard, it might take you a little longer to do that initially, because that's not a concept that's constantly reinforced in our everyday lives. That's not something that we routinely see on TV. It's not something that we think about at Christmas. When I want to put out my cookies, I'm also going to put out some mustard for Santa. So that might be long, that might take longer for us to do because it is a weaker association for us. So by measuring the amount of time it takes us to make an association between two concepts, we can determine both the direction and the strength of that association. Stronger associations happen very fastly, right? So if I say peanut butter and you say jelly, that's a strong association for you. Weaker associations take a little longer to develop. So if I say mustard and you say jelly, right? That's a weaker association. Maybe it takes you a little longer to do that. Using this concept, researchers have developed ways to test and measure implicit bias. And this can help us determine where some of our subconscious biases lie. And the IATs are really looking at comparing our speeds for pairing things that are not consistent with common stereotypes. Again, so for example, taking those common associations, milk and cookies, and then requiring you to then associate milk with something uncommon, right? Something you don't see around you that's not normalized, like mustard. And this can help us identify where our associations lie. The implicit associations test will allow you to test a number of things, both body weight. To Lee's point, it will help you to identify, do I have an implicit bias, positive or negative, based on body type? Do I have one based on gender roles? Do I have one based on religion or race or ethnicity? It will help you to identify those. I've taken quite a few of those. I was kind of surprised by what my outcomes were. Even as someone who talks about implicit bias all the time, I was really surprised where some of my subconscious associations lie, and they are often, and they were very much at odds with my conscious beliefs. But those are an opportunity for us to really see where we have opportunities to challenge ourselves and to continue to grow. And so I do want to encourage you to not be discouraged by what you may see or what your results may be when you take an IAT, but to use that as an opportunity to move forward in the right direction. I'm going to pause here. Just a quick check-in to make sure that I am communicating the information to you in a way that you are able to really kind of understand what these concepts mean and that it's all making sense. So a quick quiz for you. What is the benefit of becoming aware of your biases? I'm sorry, what is not a benefit of becoming aware of your biases? right, if your answer to this question was number 2, then you are correct. Suppression is never the goal. Suppression is never our goal. By bringing awareness to our automatic attitudes, we do not want to suppress them. We want to become aware of our unconscious biases so that we can identify times when we're most likely to act on them. We can be intentional about preventing them from influencing our decisions. We can really reflect on how these things influence our interactions, and then we can seek out experiences and resources to help us further educate ourselves. So another way to really address biases is to mitigate it through cultivating diversity, both in our personal and our professional lives. This means increased exposure. I will say for a lot of people, this is difficult. Having direct contact with individuals across lines of differences is really important for eroding some of those subconscious beliefs we have acquired over time that have really been fed to us through our surroundings. And so that is one way that we can do that, by increasing exposure directly or indirectly. And indirectly could be through films, right? Images, pictures, really looking for being intentional about finding more positive associations and counter stereotypes, right? Looking for people who are different than what that stereotype might be. So one example might be really identifying Hindu women in positions of public political power, right? Or identifying a wrestler who might identify as a member of the LGBTQ community, right? Ascribing that thought of what masculinity is or means and how that pairs with sexuality, being able to really look for those examples that reinforce that the stereotype is not as common as we've allowed ourselves to be. And then exposing ourselves to more favorable imagery, right? So that we can really adjust our subconscious associations. The next thing is to notice and to question our assumptions. And when you notice that you have made an assumption about someone, or that you've looked at someone and you thought, oh my God, they look very exotic, ask yourself, why am I thinking this way? What if the opposite were true? What if someone thought I looked exotic? I look pretty normal. What is exotic about the way I look, right? How does this align with my values? And I know those things seem kind of far out there. I'm using examples just really to kind of put it into a context, but asking yourself, how does this align with my values? So if I say I value equal opportunities for all, why does the thought of a diversity in hiring initiative make me feel as though less qualified candidates, that diverse candidates would automatically be less qualified? I believe in equal opportunities for all. So really take those times to really measure your values against those beliefs that tend to rise to the surface, that reinforce these subconscious biases that we hold. And then adapting in discomfort. It is very uncomfortable, right, to be around individuals who are different from us. That is why we flock towards, well, for some people, none of these things are absolute statements, but for some people, we tend to flock with individuals who remind us of ourselves, who look like us, who we don't have that many differences with, right? Because it's more comforting, it feels good, it's easier to do, but requiring ourselves and making a commitment to ourselves that we will adapt in those moments of discomfort, that we will identify allies to help us work through our discomfort and to keep us accountable to really cultivating diversity in our circles, so that we can create more positive interactions with others across lines of differences and ultimately enhance our professional environment. So quick question for you guys. Which of the following factors will increase the likelihood that implicit bias can occur in the professional setting? And if you like, you can respond in the chat section. Overconfidence in your own personal objectivity, compromised cognitive control. That means basically you're really busy. You've got a lot on your mind. You've got a lot of things to do, so you don't have time for this. Or 3, high ambiguity. Or 4, all of the above. So if you chose for all of the above, you are absolutely correct. Michelle Rich is my A+ student. We are practicing law in one way or another. We are engaged in the profession of law, and we as a profession are the most susceptible to acting on or over-relying on our own implicit biases. We work under time constraints. We are very busy all the time, and fatigued quite often. And so this is the environment that fosters and allows implicit biases to run rampant. This is the type of environment where we can over-rely, right, on that gut instinct, which is fueled by our implicit associations, which often reinforce stereotypes and prejudices that we may see in society or across society. And so one tool for mitigating bias in professional decision-making or in our professional capacity is deliberative processing. You know, some very specific reasons for the importance of deliberative processing is that it helps us to identify our bias and to really think through very critically how is my bias manifesting in what I'm looking at, and the additional layers of personal bias that I'm bringing to that. So where is bias really inherent in this situation? And then what biases am I bringing to it that may exacerbate that? And this allows us to adjust our thinking accordingly so that we can really see the matter as a whole and not through that slanted lens. It gives us a better understanding of what issues are in front of us, what the facts really are, and it makes us better advocates. It makes us more effective in achieving our outcomes. Now, bias is not necessarily bad all the time. It's simply a preferred way of looking at things, right? This is our brain's shortcut. It makes it easier for us to accomplish things. We have these shortcuts that we can take, but being aware of what our subconscious shortcuts are and really being intentional about addressing the negative ones will really help us to move forward in a way that is more culturally sensitive and actually promotes civility in the practice of law. So deliberative processing is more oriented towards the problem, the issue, or a situation that you're addressing, right? Helping you to understand it and really to eliminate, to the extent possible, these biases, except where they become a part of eliminates to the extent possible are these biases and emotional reactions, right? It's just about impossible to eliminate all emotions or to completely divorce yourself from your own deeply held assumptions, but you can try to understand that they're present, analyze them, and then try to work around them. It gives you the whole picture and it gives you a more accurate view of reality. So the last thing we'll cover is interrupting third-party bias. And then also I'm gonna include a little piece about, interrupting your own bias when you catch it, right? And so one thing that often comes up when I talk about microaggressions is, oh my God, I didn't realize that was offensive, or I didn't mean to hurt that person or harm that person when I made that comment or when I told that joke. How do I fix this? What do I do? I think acknowledging where you've made a mistake or where you've misspoke or where you've engaged in a behavior that might be offensive, acknowledging that to that person and apologizing, simply apologizing. And one thing I will say is really important that you not in those moments make that person responsible for comforting you. And I want to make sure I'm explaining this clearly, but for example, if I say something that offends my colleague, John, I say something that's very culturally insensitive, and I realize and I say, oh my God, John, I'm so sorry. Please forgive me. I can't believe I said that. I feel like I'm the worst person on the face of the earth. I don't know what I was thinking. And now John feels this obligation to comfort me, right? And to help me through my my anxious response, my overly emotional response to my misstep. That is an unfair burden to shift to my colleague, John. And so very easily, and people respect this, acknowledge it, apologize, move forward. Move forward. If you are still struggling with it, if you're really wrestling with it emotionally and you're not quite sure how to clear it up, or you feel really bad, apologize, resolve that within yourself. Apologize and move forward so that relationship can heal, right? Because what we often find is that individuals who have been the recipients of microaggressions or on that end receiving them often feel very exhausted by the idea of having to not only endure that, right? Because there's that pain that comes with that, there's that offense that comes with that. So we were already trying to manage ourselves and remaining professional and polite, right? Because we want to continue a positive relationship to the extent possible. But it's hard to do that when I also have to now comfort you and educate you, right? Because you're having a crisis. And so what I will say, and I always encourage people, acknowledge it and apologize, and then quickly move forward from that. People will respect you for it and they will appreciate that. Now, if you are in a group or if you are with someone and you hear someone acting or speaking in a way that manifests third-party bias or some type of bias on their parts, speak out. Whether you decide to do that through a private conversation with that individual or through public forums where we have conversations and trainings around these topics, is really important to address the issue immediately and openly, right? Here's what was said. Here's why that's offensive. And be very open and transparent about that. But instead of pointing the finger, assigning names, right? Name calling or blaming individuals, focus on the issue, what was said, what was done, and what the value is. So if I said something that was really offensive, it's not in alignment with this value. We value fairness. We value equity. We treat people with dignity and respect, right? And then listen to understand all points of view, both the speaker and the person who was the recipient of those words. Just listen to understand, respond with empathy, speak for yourself, use I only statements, and then ask for help when needed. Some situations, some aggressions, some manifestations of bias are too large for us to do by ourselves, right? So my colleague was in court and felt attacked by the judge's reference to them and how the judge responded to hearing what their name was. My colleague was not in a position where they did not have the ability to respond to that in a way. And so they asked for help, right? And they needed help in that moment. They needed someone with them to help address the issue with the judge so that everyone can move forward in a way that's professional and positive. The next option is really to create systems of accountability, both for yourself. So self-accountability. How will I keep myself accountable? What will I need to have in place? Do I need an accountability partner, someone who can help keep me accountable as well? And then within our institutions, our organizations. So what are our organizational values? What are our firm values? What does this organization stand for? What do we believe? And when things are said or done that's inconsistent with those values, aligning those behaviors, those words, those actions with those values and allowing that to be the discussion. And so I always encourage people to not point the finger, to not name call. It's really hard to have productive and rehabilitative conversations around these issues when we've ascribed characteristics to people or we've assigned labels to people, right? And so when we're thinking about our profession and really maintaining these levels of civility and professionalism is more beneficial for us to identify behavior and words and to align those with values. So not John is a bad person or Latasha is a bad person. This comment was a bad comment. That behavior was an unacceptable behavior. Here's how it does not align with our values or is inconsistent with who we are as individuals and as professionals. And then engaging in collective correction. So when necessary, when there is a culture that is not inclusive, where biases are really running rampant, or where, you know, you're at your bar association meeting and around the table, everybody's telling inappropriate jokes about women or people of different religious background. There's already a culture there, right? And so really engaging in that collective correction that allows the organization, that institution to move forward as a whole beyond that. So I am at my time for today. I did want to leave a few minutes in case people had questions or comments or things they really wanted to kind of talk about before we wrapped up. I will say just a couple of pointers just to take away from the conversation is really having implicit biases is a part of being human. It just is. And our cognitive functioning really relies on implicit associations, but it is our responsibility to recognize where these implicit biases where these implicit biases make it difficult for us to really live up to those values that we ascribe to, right? And how can we create opportunities to mitigate the negative outcomes from that? How can we avoid these first impressions or gut instincts when we're making decisions that impact others? And then how can we be more intentional about incorporating these into our practice and into our daily lives? So I see a question from Lee. How well do you feel that the MAI bias instruction given in every civil case acts to draw out bias? That is a good question. I actually, to be honestly, I don't have any experience with that instruction, so I am not sure how effective it has been. I wonder if anyone else on the call has any thoughts about that? Yeah, I would hate to respond and not have seen it or not have looked at any research around it. I don't want to make things up. But no, I am, I would love to look at it, take a look at it and look into it. And if you likely, feel free to reach out to me, and if you want to share it with me, I can look at it and we can chat about the language and how it's organized, and whether that's effective language to use in an instruction like that, just based on other experience that I've had. But if there are no other questions or comments, I thank you all again for having me and for bearing through the presentation. At the end of the day, I know you guys have been in a long CLE. Thank you again, Rob.
Latasha, thank you so much. That was really, really outstanding. The materials that you had both in your PowerPoint and the materials that we had already forwarded really, I think, make us all reflect on how we can improve what we do every day, especially in our profession. And we thank you. It's such an important part of our legal ethics, and you are a terrific resource. And thank you again for giving of your time and your expertise. To everyone who's on our Zoom, thank you all for attending. It's with your donations going to these various nonprofits, including Legal Services of Eastern Missouri, Land of Lincoln Legal Services in Southern Illinois, the Kornblum Food Pantry, and the St. Louis Mediation Project. Please save the date for June 24. We will have a full day webinar. That'll be our next best practice program. We look forward to seeing you then. Be on the lookout for the flyer in the next couple of weeks. And we hope you all have a safe and healthy time. Have a good evening. Thanks again for joining us.